session.
Good evening, one and all. The first session is, there are three topics insofar as the session is concerned. One is maritime, second commercial, and third insolvency laws. The first session is chaired by Honorable Justice R. Suresh Kumar. The chair will obviously be leading the session. Thereafter, it will be followed by discussions relating to all these three topics. The discussions will predominantly be insofar as the speakers are concerned, Honorable Justice R. Sendil Kumar, and thereafter Mr. Om Prakash, and then my two friends from Singapore, Mr. Jainin and Alexander. And I will be moderating it, but certainly they would be having the meat of the entire discussion here. Now, I would request Honorable Mr. Justice R. Suresh Kumar to speak on these three topics as a chair, and then we will proceed with the discussion.
Mr. Sendil Kumar Ramamurthy, Brother Judge from Madras High Court, Brother Justices Satish Kumar, Krishnan Ramaswamy, former Judge of this court, Brother Chandrasekhar, Justice M. Sundar and Justice Bharata Chakravarti are expected to join in the next session. Soon they may join. The senior advocates, Mr. Vijay Narayan, Mr. Om Prakash. Today's guest from Singapore, Mr. Jainil Bandari, Mr. Alexander Jiajiu, Mr. Avinash Pradhan, and Mr. Divesh Menon, the President of the Madras Bar Association, Mr. M. Bhaskar, Secretary Mr. S. Trivengadam. The main pillars of this meeting, Mr. Naveen Kumar Murthy, Advocate, Mr. Arjun Singh, Advocate, going to be the moderators. The senior advocates, my dear young lawyers, good evening to one and all. That we know the relationship between India and Singapore dates back to several centuries ago. As many number of people belong to this part of the country, that is India, had migrated several generations ago and settled at Singapore. They have gone to Singapore, settled there, means they have taken jobs there, they started industries, they started commercial establishments. And if you see the scenario in Singapore, though it is a country inviting all from the globe to have business, to have commercial ventures, the majority of the commercial transactions might be undertaken by few country people who would have the origin from few countries, out of which India will always be in the forerunner. That kind of relationship between these two countries have been evergreen and everlasting. So from the country Singapore, today we have received 4 of our guests. All the 4 are associated with one of the leading law firm, Raja and Tan Asia, at Singapore. Inviting them, the Madras Bar Association, with the help of Mr. Naveen Kumar Murthy and Arjun Suresh and other friends, have organized this Less Chartered 2025 India-Singapore Bar Dialogue. Definitely which will be a useful program for the lawyers community, especially the young lawyers. There are two sessions today. Insofar as the first session, 3 topics have been given: maritime law, commercial law, and insolvency law. You all know that all these 3 branches of law have interconnection or interlinked. If we look at the provisions of the respective legislations, these fields now being governed by 3 legislations. The insolvency law is governed by IBC, Insolvency and Bankruptcy Code. The commercial litigations area is governed by the Commercial Courts Act, and the maritime law, since has been consolidated, a new law has come, that is 2017 Act. So these 3 legislations mainly governing these 3 fields. Insofar as the insolvency laws are concerned, Mr. Senthil Kumar Ramamurthy, Justice Senthil Kumar Ramamurthy and Senior Advocate Mr. Om Prakash will speak much about on the insight of the insolvency laws, especially under the IBC. This IBC of the year 2016 has come as a consolidated legislation, prior to which, you know well, there are a lot of litigations which touching upon the insolvency and bankruptcy area. As far as the companies are concerned, that the companies law which governed the field, and for even individuals, the Provincial Insolvency Act, under the Presidency Insolvency Act, so old legislations which governed the field. And in some areas, the debt recovery tribunals, that act, as well as the SARFAESI Act, governed the field. Therefore, insofar as these commercial ventures are concerned, maybe a company, maybe a partnership firm, maybe a proprietary concern, or even an individual, against whom, if the resolution with regard to the insolvency and bankruptcy have to be resolved, people have to approach several forums. As originally there were company law board, subsequently the company law tribunal, till one point of time that the high courts have exercised the jurisdiction. And insofar as the SARFAESI and other acts, that we have to go to the debt recovery tribunals. For Insolvency Act, Presidential and Provincial Insolvency Act, we have to go to the courts which had the jurisdiction to decide those cases. And these kind of multi-forum in judicial side to resolve these insolvency issues and bankruptcy issues certainly created much inconvenience to the litigants. Therefore, the legislature thought it fit to consolidate everything and bring a solitary legislation, with the result of which IBC had come. The main difference between the erstwhile insolvency laws and IBC, normally under the old system, the creditors will immediately go for liquidation process. They will go to the court and file a petition, seek for liquidation. But a paradigm shift has been made under the IBC, where first we must explore the possibility of resolution. If the issue is resolved, the company need not go for any liquidation process. If only the resolution failed, then only we have to go for the liquidation. That is a major development which has been brought by IBC. As far as the commercial laws are concerned, the Commercial Courts Act, which is one of the long-felt need, this Commercial Courts Act is having only 23 sections, you all know. It does not make any major difference because whatever the litigations we used to call is as a civil litigations that were resolved by the regular civil courts, and wherever the High Court is having the ordinary original civil jurisdiction, High Courts will take it and resolve it. But the thing is, once a suit for recovery of money, suit for any commercial transaction, suit for interpretation of any agreement on the commercial side is to be resolved to get a degree, even from the trial court, we have to wait for at least for a decade. Then once appeal is filed, you know well how much time the appellate court will take, and the second appeal is filed. At least 20 to 30 years, minimum 2 to 3 decades, that every litigation has to cross to see the light ultimately. So this kind of time consumption will be a detrimental to the progression, commercial progression of the country, that will directly and indirectly will have a bearing on the economical development of a country like India. Therefore, the Commercial Courts Act mainly focusing on two issues. One is that it is an exclusivity. In the Indian judicial system, tribunalization is one side, special enactments had come, special courts have been constituted, but in so far as commercial litigations are concerned, that is not the special litigations, it's a regular litigations only, but in order to speed up the process of justice dispensation system in resolving the commercial disputes, that we have first time the exclusivity, and in the Commercial Courts Act, only the commercial litigations will be taken up. Originally, you know well that the jurisdiction, the pecuniary jurisdiction was 1 crore. Now it has been reduced to 3 lakhs. You know well what is the value of the money of 3 lakhs in Indian rupee here. Even a litigation of rupees, worth about rupees 3 lakhs has to go before only the commercial court. Almost all the commercial litigation will go to the special courts, that is commercial courts. The intention being, not even a small amount should struck because of the litigation. People are investing money, hard-earned money are invested by individuals, group of individuals. Even for instance, if it is a company, a public limited company, the public limited company is having the people are having shareholding in the public limited company, therefore it is ultimately is public money, general money. When this money is poured for any commercial things, in commercial establishment or commercial progression, where there has been a litigious area, because of the litigation, if everything struck for years together, decades together, certainly that will hamper the economic progression of any country like India being a developing country. Therefore, the Commercial Courts Act is a boon for developing the economical progression, ensuring the economical progression of the country. Therefore, from that point of view only we must look at the commercial courts. Main object of these laws, either IBC or the Commercial Courts Act, in order to ease of doing the business. The theory of ease to doing the business is the main objective of both the Commercial Courts Act as well as IBC. The next topic that also has been given for discussion in the first session is this maritime law. In so far as this maritime law is concerned, that it is a subject which may not be familiar to many of the lawyers. Very few lawyers would have practiced over the Admiralty jurisdiction. In those days, the Admiralty jurisdiction was exercised only by few high courts. High Court of Bombay, High Court of Calcutta, High Court of Madras. So, Madras High Court being one of the pioneer in exercising the admiralty jurisdiction, at least we may have some say. Now, by virtue of this act, that is a 2017 Admiralty Act, the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017 is concerned, the earlier colonial legislation of the 19th century, like the Admiralty Act 1840 and 1861, the Admiralty Act 1880 and 1891, and also some provisions of the Letters Patent Act also had been scrapped, and one consolidated legislation has been brought in, that is Admiralty Act 2017. It consists of only 17 provisions. What is a maritime claim? What is the Admiralty jurisdiction? Admiralty jurisdiction is nothing but if a High Court is exercising the Admiralty jurisdiction, the territorial waters coming under the jurisdiction of the High Court. Territorial water means touching the border of the international water. To that level, the Admiralty jurisdiction can be extended to High Court, and this can be modified and extended by the notification to be issued in this regard by the central government. That kind of provision is also available. And insofar as the maritime claim is concerned, all Admiralty jurisdiction claims that a vessel is to be detained, the goods, whether it is perishable or not, whether it is live goods or not, how to be maintained, how to be retained, how to be dispersed, and individual claims, claim of a company, claim of a creditor, whatever the litigious area pertaining to a vessel, that can be claimed, that can be construed as a maritime claim, and all those maritime claims have to be dealt with only by the courts exercising the Admiralty jurisdiction. If you look at the provisions of these three acts, they are interconnected. In each and every of these three enactments, there is a provision. Suppose CPC will apply. CPC will apply to all these cases. So CPC is the commonality. Procedure-wise, CPC is the commonality which is applying, which is applied. And insofar as the other commercial nature of the litigation is concerned, these three fields are not only the growing field, but also these are all the three fields which may grow further. Therefore, the young lawyers who want to practice in this field certainly must have an expertise in these three branches of law. And therefore, I hope this session for the next nearly about 1 hour with experts will definitely give some useful tips and insight about these three fields. And I hope and trust this session will be a successful one. With these words, let me give to the next speaker. Thank you.
Thank you. Thank you to Honorable Justice R. Suresh Kumar for the insightful introduction insofar as these three topics are concerned. So I will start with Honorable Justice Senthil Kumar Ramamurthy, considering that as what fell from the chair, that yes, Admiralty, the Act, Jurisdiction and Settlement of Maritime Claims, is a consolidated act over a period of time. We have now come to 2017 with this act. This act obviously deals with jurisdiction, and more particularly insofar as actions in rem and actions in personam. And your Lordship had recently authored a judgment, and the judgment is Shipping Corporation of India versus Nicholas John Richardson, which is 19th October 2024, where your Lordship dealt with the actions in rem versus actions in personam, while that judgment was with regard to actions in personam, but your Lordship did also touch upon actions in rem in that matter. Now, what we see from the judgment, as well as the statute, obviously, is that actions in rem suffice if the vessel is within the territorial jurisdiction of the respective high courts for one to exercise jurisdiction. Actions in personam as well, that would be the yardstick, but for the restrictions placed under Section 7 of the Act. Now, the question that I ask your Lordship is, why is it that there is a restriction under Section 7, whereby 7 states that the requirement for either the cause of action or for the defendant to have business or reside within that jurisdiction is required only for 7 and not for other forms of actions in personam claims.
Before I proceed to answer the question, at the outset, I must thank the Bar Association and Raja and Tan. Good evening to my co-panelists, present and former colleagues who are here, lawyers assembled here. I must also begin with a caveat, because the question concerns a judgment I authored. So obviously it is quite possible for the aggrieved person to carry the matter in appeal, and whatever I have said is clearly not the final word on the subject. So subject to this caveat, you see, the Admiralty Act of 2017 deals with both actions in rem and actions in personam. As far as actions in rem are concerned, they are dealt with in sections 4 and 5. And clearly the basis of exercise of jurisdiction is the presence of the vessel concerned within the appellate jurisdiction of a particular high court. Whichever be that high court in India, that high court exercises jurisdiction. So the problem that arose in the case you mentioned is that it was an action in personam pertaining to an alleged collision. Therefore, it was a maritime claim that fell within the scope of Section 7 of the statute. And Section 7 imposes certain restrictions, or so the heading says. But the provision proceeds to stipulate that a court can exercise jurisdiction if the cause of action arose wholly or partly within India, or if the defendants reside or carry on business within India. Unlike other provisions, it doesn't speak of cause of action arising within the jurisdiction of the court. It speaks of within cause of action arising within India, defendants residing or carrying on business within India. So on that basis, contention was raised that any high court within India can exercise jurisdiction provided cause of action arose within the territory of India or the defendants are within the territory of India. I examined this in the context of the entire statute. Now, Section 3 is a generic provision which deals with the exercise of admiralty jurisdiction. Unfortunately, Section 3 is made subject to Sections 4 and 5. It doesn't contain a direct reference to Section 6 or 7. Therefore, the question arises whether the jurisdiction under Section 7 is wider than the jurisdiction ordinarily exercised even in proceedings in rem. Clearly, in my view, that was not the intention. The heading of the section itself indicates it's intended to impose additional restrictions with regard to the classes of cases dealt with in Section 7. In other words, to understand the provision correctly, you'll have to contradistinguish with the jurisdiction exercised in an action in rem, where you can exercise jurisdiction as long as the vessel is within the appellate jurisdiction, irrespective of other aspects. Whereas under Section 7, because it's limited to claims relating to collisions, maneuvers, violations of regulations under the Merchant Shipping Act, therefore additional requirements are imposed. The idea is that you can't exercise in personam jurisdiction merely because the vessel is presently within jurisdiction. because it's quite likely in these collision matters that the vessel may be flying, a foreign flag. The owner may well be a foreigner. While you'll be able to exercise in rem jurisdiction provided the vessel is within your jurisdiction, you cannot exercise in personam jurisdiction unless you satisfy the additional requirements in Section 7. That is how I understood and interpreted it.
Thank you, sir. Insofar as the context in Singapore is concerned, the 1961 Act is what is applicable, and this question is posed to Mr. Jain. Now, I noticed that Section 3 of the Act, unlike our Act, refers to it as questions and claims, whereas in our Act, it refers to as maritime claims. But my question are twofold. Could you provide a brief overview on the exercise of the General Division of the Singapore High Court when it comes to actions in rem and actions in personam? And do you find any major or noticeable differences between the more recent 2017 Act in India vis-a-vis the 1961 Act of Singapore?
Yes, thank you, Arjun. Honorable judges, fellow advocates, it's indeed an honor to be here to address all of you. And Arjun, your question can be addressed several ways, but what I will do first is talk about the overview, right? The Act in Singapore, the Admiralty Jurisdiction Act, is somewhat similar to the Indian 2017 Act in the sense that we do have provisions there for the exercise of Admiralty jurisdiction in rem and Admiralty jurisdiction in personam. Now, the difference is as in the case of an Admiralty action in personam, we proceed personally against the defendant, in which case you have to serve the proceedings on the defendant as a person, as opposed to proceeding in rem against the res or the ship itself. So the advantage of proceeding in rem is you get pre-judgment security, because you can arrest the vessel as security before you obtain a judgment. So that's the obvious advantage. So what does the Singapore Act spells out is in Section 3, although the word maritime claims is not used, right, it does spell out in detail the types of claims pursuant to which you can bring either an action in rem or an action in personam. Now, these claims are very similar to the type of maritime claims that you have under the 2017 Act. Basically, they relate to claims concerning possession and ownership of the vessel, claims under a mortgage, claims relating to the use or hire of a ship, carriage of goods on board a ship, salvage, wages, ship construction, ship repair, right? So the whole list of claims is there. It's very similar. But there are some differences. And I'll just highlight a few differences in the sense that the types of claims under the 2017 Act is broader. Broader because you have Admiralty jurisdiction that is exercisable for claims arising out of a contract of sale and purchase of a ship, a claim for insurance premiums. Now, the Singapore Act does not have that. So if an insurer is owed insurance premiums, you can't arrest the vessel. You have to proceed in personam against the ship owner who owes you the premiums. Right, so that's number one. Secondly, there is a specific section in your Indian Act that deals with agencies' fees. But in Singapore, there is no specific provision for agencies' fees. And if a ship agent is owed fees, you need to bring it together with disbursements that are owed. Because under common law, you can include your fees with the disbursements. That's the second difference. The third is that in terms of environmental damage, for example, pollution, you have a specific provision in your 2017 Act that says that ship that causes environmental damage, anyone who suffers that damage can bring a maritime claim. In Singapore, there is no provision in the 61 Act that confers jurisdiction, but Section 31D, which deals with damage done by the ship, has been extended to cover oil pollution and bunker pollution claims under our Singapore legislation that gives effect to the CLC Convention and the Bunker Convention. So that's been extended. And for wreck removal also, in your Indian Act, you have a specific provision that confers jurisdiction or admiralty jurisdiction for wreck removal claims. And in Singapore, again, Section 31L, which deals with salvage, has been extended to include wreck removal under the Merchant Shipping Wreck Removal Act, which gives effect to the Nairobi Convention. So these are the differences when it comes to in terms of the type of maritime claims. Now, how do you exercise the jurisdiction? The Singapore Act provides that as long as you have a maritime claim, in all cases, you can exercise jurisdiction in personam, provided you can serve the writ on the defendant. But there is a similar restriction to Section 7 for collision cases, which is Section 5 of our Act. And Section 5 is worded slightly differently because Section 5 confers jurisdiction for collision cases in personam where the defendant is either habitually resident or has a place of business in Singapore, or if the cause of action arose either within the inland waters or port limits of Singapore. So it's slightly different from India, because in India it says as long as the cause of action arises in India, right? And then you had the problem here also because you have a large country, you have got different territorial jurisdictions. Your high courts have different territorial jurisdictions, right? Whereas in Singapore, there is just one general division of the High Court, and it's a small country, right? So the collision jurisdiction, therefore, is slightly different. And we also have another provision which says that if you have another action arising out of the same incident or a similar series of incidents that is already brought in Singapore or has been determined in Singapore, then you can bring an action. So this typically happens in a collision, because in a collision, you have competing claims, because both ships generally will claim against each other. So if one ship has already brought an action in Singapore and that is proceeding, right, by the mere fact that that has happened, the other ship can also bring an action in Singapore. So that also confers in personam jurisdiction for collision matters. I think I've kind of given you a quick flavor of the major similarities and differences.
Correct.
Right?
Correct. And having said that, you also said it's broader here, and we have A to W, which is about 23 heads under maritime claims.
Yes.
Having said, you also refer to the general division, which exercises jurisdiction in Singapore. My question is, you also have the Singapore International and Commercial Court, right, the SICC. Now, I understand that you need both. It has to be international as well as commercial for the court to exercise jurisdiction. Do maritime claims, or in that admiralty proceedings, are they also lodged before the SICC? I mean, you or Alex could answer that.
I ask Alex to answer it.
Please.
Thank you, Arjun. And let me just quickly echo what everyone before me has said. It is a privilege to be here, and thank you for the opportunity to address you on this. Let me answer the question in a couple of quick points. Now, the Singapore International Commercial Court is actually part of the General Division of the High Court of Singapore. So the Admiralty jurisdiction of the High Court is exercisable by the General Division, and that includes the SICC. The rules of court that we have actually distinguish between the two. So we have one set of rules that applies in the High Court other than the SICC, and then we have the SICC rules. Both sets of these rules were updated in 2021, about 4 years ago. And the rules that apply to the SICC envisage the application of Admiralty jurisdiction in certain cases, because there is an express provision in those rules that says where the SICC is hearing Admiralty matters, the same rules apply as in the domestic General Division of the High Court. So as far as the rules and the procedure is concerned, there is virtually no distinction, because the SICC rules simply follow what the standard rules of court would require parties to do. Now, in practice, the SICC seldom functions as the court of original jurisdiction when it comes to Admiralty matters. And one of the reasons for that is the requirement that matters need to be both international and commercial in nature in order to go before the SICC. Now, for a matter to be commercial in nature, the rules prescribe that it has to arise out of a commercial relationship, or a relationship that is of a commercial nature. That in itself is quite a broad requirement, but we've talked a lot about collisions over the last few minutes. A collision case would not arise out of a commercial relationship. So cases like that would naturally not come within the jurisdiction of the SICC. So as a matter of practice, virtually all Admiralty cases are commenced in the General Division rather than the SICC. There could be situations where if you have a contract for, let's say, the use or hire of a ship, and the parties have somehow agreed an exclusive jurisdiction clause in favor of the SICC, that you might have an Admiralty action commenced in that division. But as far as I'm aware, that has not actually happened yet, at least since the rules were updated a few years ago. But we may see a case like that in the future. Now, all that said, the SICC can and does deal with matters that are, more broadly speaking, of a maritime nature. And it can do so in two situations. One, if the matter is commenced in the SICC, because it is the forum that the parties have chosen to bring proceedings in, or the court may transfer a matter from the General Division to the SICC if certain requirements are met. So if the requirements of the matter being international and commercial are satisfied, the court registry will proactively monitor cases and suggest to the parties that they should be transferred. If the parties are unable to provide a compelling reason why those matters should not be transferred to the SICC, then they will be transferred to the SICC and docketed before a judge in the international court. So that includes matters in the nature of maritime claims. It can include marine insurance matters. It can include marine charter party cases and other commercial disputes. As long as those requirements are met, they can go before the SICC.
Thank you. Thank you, Alex. Now, to only come back to the insolvency laws, and therefore I will address this to Mr. Om Prakash. Sir, IBC 2016, which has been here for the last 8 years, was meant to focus on resolution and rehabilitation of a corporate debtor after declaring moratorium. Sir, has the code, in your opinion, achieved the object that it was meant to, observing it for the last 8 years of its operation?
Good evening, everybody. Honorable judges on the stage and off the stage, my friends from Singapore. At the first instance, I thank you for having given this opportunity. Now, coming back to the query of Mr. Arjun Suresh, when we speak about IBC, there are two primary things which I would always like to put across. One is that the evolution of this law. The small, brief historical fact remains that the code was enacted on the basis of a committee's report which suggested consolidation of all the laws relating to insolvency. Now, while this committee made these suggestions, they had taken the best practices from various jurisdictions like UK, US, Singapore, Hong Kong, Australia. So the very enactment came in a context of a modern world. Now, secondly, when this enactment was put to challenge before the Honorable Supreme Court in the Swiss Ribbons case, the Supreme Court upheld the code using the words that there is an experimentation which is being done. The legislature is seeking to experiment. And over the period of time when the code was in existence, there had been certain challenges which had come. And in the context of the challenges, there were amendments which were brought in. So the code was taking different shapes as it passed through years, and therefore the experimentation should be permitted is what the Supreme Court said. Now on the question that the Insolvency and Bankruptcy Code was looking at resolution and whether we have achieved that over the period of time. The objective of the code is effectively the insolvency resolution. As His Lordship Justice Suresh Kumar said, the earlier regime of the insolvency of companies are concerned, it was only a petition which goes for a winding up. The moment a winding up is ordered, what was looked as a liquidation. You call for the claims, you seek to address the various creditors by liquidating the assets. Now that has been completely changed. The code by its objective seeks to resolve the insolvency situation so that the company is back on its feet and it gets on. And if you look at that objective, yes, it has achieved. Over these 8 years, the experience shows that this achievement has been made in terms of various corporates which are back onto their feet, forgetting whatever financial distress it had faced. The code by itself, as well as the Honorable Supreme Court's judgment, makes it clear once an insolvency resolution happens, there is a resolution plan which is put into place. All old debt stands extinguished. So therefore, it is on a clean slate principle which goes forward. Now, having said this, there are certain other things which may also have some attention which we need to consider. One is that the code by itself had came into existence on a purported failure of earlier statutes. You had that series of statutes which tried to address the situations. For example, SICA, the forum created by SICA in BAFR, and it is our High Court in one of the full bench judgment which recorded as to what was the results in a BAFR proceedings, pointing out to the fact that over a period of 20 years, BAFR was able to show that only about 196 companies were able to be rehabilitated. Otherwise, it was only the long period of time. 20 years the company survives because of a BAFR proceedings. Post that, it goes to a natural death. So from that regime, we had come to a situation of where we are looking at resolutions. Now, two factual figures which come out is that one of the statement which was made by the Honorable Minister in the Parliament just a few days back, saying that from the inception of the code till date, it is about 40,000 and odd cases are the companies by virtue of petitions in numbers which got resolved. And the figures which they have pointed out is that 10 lakh crores of debt has been recovered. The other factor which they said is that from the time when SURFACE was there, which was one other measurement as to the insolvency resolution or recovery of the debts by the banks and financial institutions, from about 23%, they have said that today the recovery is about 46%. Now, other figures which are there is that the resolutions which had happened in IBC, manufacturing sector, or the other way around is that the resolutions were about 54%, the liquidations were about 46%. So it is still hanging on a point of nearly 50% mark. The resolution did not reach what was required. So many cases have gone for liquidation, it has happened. Now on the resolution as well as in the liquidation, the other figures which are shown is that in terms of recovery or getting back or plowing back the money into the system, the statistic shows it is about 210%. On a liquidation value, if you have seen in terms of the old winding up proceedings and liquidations which had happened, 100 rupees which you have recovered by virtue of IBC proceedings, today it is about 250 rupees which either gets recovered or gets resolved or back into the system. So considering all these factors, the experience shows that there has been a path towards resolution of insolvency of companies.
Sir, thank you very much. Since you had brought up, sir, the SICA, which is now obviously it's been repealed, and then the BIFR is no more. Sir, but in the context of Chapter 11, under the US Bankruptcy Code, it is more in the nature of a debtor-driven model, like the SICA, and whereas now it is more a creditor-driven, unlike how it would be a debtor in possession or driven model. Therefore, would this be a more advantageous manner in proceeding further, considering that it's a creditor-driven, vis-a-vis a debtor. And this is both to Honorable Justice Sendil Kumar as well as...
See, again, I have to pick up, from where Mr. Om Prakash left off. You can't look at this statute, divorced from the context. As he briefly mentioned, previously for insolvency resolution, you only had the Sikh Industrial Companies Special Provisions Act, under which the Board for Industrial and Financial Reconstruction was constituted only in New Delhi. This statute applied only to industrial companies as defined in the schedule to the Industries Development and Regulation Act. And because it was situated in only one place in India, it was extremely unsuccessful, and most defaulting creditors primarily used it to rely on the moratorium that would kick in the moment a reference was made under Section 15. So the IBC arose not only against the statutory context, it also was enacted in the factual context of non-performing assets in India ballooning to, unmanageable proportions. And, these non-performing assets were largely large loans extended by banks and financial institutions to corporate entities, which is why the statute was designed primarily keeping, the banks in mind. In other words, secured creditors. Therefore, you will find it may not be incorrect to say that operational creditors got a bit of a short shrift under the statute, primarily because of what the statute was designed to do. So, in fact, in the shortly after enactment, the RBI referred 12 cases. Many of these cases related to large steel companies. There were a few infrastructure companies. You had SR Steel, Bhushan Steel, and the like. And you had remarkably strong resolutions in many of those cases. It so happened that the steel industry was on the upswing almost at the time when these matters were referred to the NCLT. So, the strength of this statute is if the underlying business has high value, chances are a resolution applicant will pick up the business. Unlike in the case of SARFAESI, where it's dependent on the value of the assets. If the asset cover is sufficient, chances are that a bank or financial institution will resort to SARFAESI. On the other hand, if they feel the asset value is insufficient, which is likely to be the case in most large ticket loans, then the IBC would be successful provided the business carries sufficient value. And as time passes, the business will also start losing value, which is why timelines become so critical to the statute. So this is the historical reason why India opted for a creditor-driven model rather than a debtor-in-possession model, which was used, under the SICA, and which is what happens in the United States under Chapter 11.
Would you like to add anything, sir, to that?
To add to what Justice Sendil Kumar Ramamurthy had said, as you said, the US model is on the basis of debtor-driven. The word was very, very clear on the terms. What, as far as IBC is concerned, what they use the words is that debtor-controlled to creditor-controlled. Today we have got into this situation of debtor losing the control. So earlier, US system was on the debtor-driven. They gave that leverage where the debtor can address the situation within a timeline. And if you are not able to address the situation, then you are out of the situation. Yes. Now, we had similar something where the debtor had that opportunity when we refer to BAFR, because they were initiating the process. They were in a position to provide the required impetus for the creditors to take a call. But that had become a drastic failure. So when IBC came, instead of driven, the legislature intended that let us put control. So today, debtor is taken away from the control and creditor is put into control. So which effectively means the IBC provisions drive basis of whatever the committee of creditors decide, which is the COC. While we say it is the creditor in control, for the purpose of driving the system, the code recognizes a neutral person in the name of a resolution professional who runs the entire show from the time when the corporate insolvency resolution commences and till the time when the resolution happens. On failure of resolution, it goes back to the liquidator. Now, when we speak about the resolution professional, if you go by the provisions of the code, most of the things are in the hands of the COC. It is the decision of the COC which the RP has required to carry forward. Therefore, the control has now come to the creditors. Now, having said that, one more important aspect which may have to consider is that these creditors, as far as IBC is concerned, there is a very big shift which had happened. Earlier, we were looking at creditors whether it is secured or unsecured. We did not have any other classification. Today, you will see, as far as IBC is concerned, the creditors are classified into two. One is financial creditors, the other one is operational creditors. So, having said creditors control, fact remains, and the reality is that it is the financial creditors who are controlling. So, therefore, a small word of caution or something which has to evolve is that what happens to these operational creditors. In many cases, the grievance or the fact reality is that when I said about 46% is a recovery which the minister has said in the parliament, this also has to be seen in the context that all the operational creditors have been completely wiped off. Today, by virtue of IBC provisions, the moment a resolution happens, claims of all operational creditors are received, and while the resolution happens, invariably only the financial creditors are paid. Many cases, it is zero value for the operational creditors, or it is either 1%, 5% or 10%. Beyond that, it is not there. And given the situation, as I said earlier, it stands extinguished. So imagine a case of a SARFAESI. The bank would have sold the secured asset and realized, but there is still something left. An operational creditor may have something to look at the business or the promoters. Today, that is not there. So therefore, those creditors will get defeated. So creditors means financial creditors and banks and finance. Thank you.
What is your suggestion? Well, this is the drawbacks that suppose after some years of IBC that we now realized these operational creditors are completely wiped out. It's like a one-sided one. Whether you suggest for any amendment or that what is the improvement that you suggest?
Definitely there is a requirement of looking into that aspect of ensuring these operational creditors are not defeated in toto. So therefore, either the legislature has to come up with some amendments which would protect the interest of the operational creditors also. As on date, the entire drive seems to be, as Justice Sendilkumar Ramurthy said, there was a huge NPA. So let us look at that the banks recover. So let us look at that the financial institutions recover. But at some point of time, this is going to come to a kind of a stagnation. Today itself, the statistics show that petitions, nearly about 10,000 and odd petitions, got resolved even before commencement. So the moment today a petition is filed in an IBC, there is all possibility things are getting settled. So of those settlements, there are cases of operational creditors also, which is a reality, which we need to. So therefore, going forward, if there is an impetus which is given for the operational creditors in terms of initiation or in terms of a role to be played, that will protect their interest. So suggestion would be some amendments which has to be brought in terms of triggering, in terms of role to be played in the corporate insolvency resolution. Thank you.
Yes, sir. Even I have noted sometimes the percentage of outstanding insofar as operational creditors are concerned is much more than financial creditors. Yet they don't have any say. They can participate in the COC meetings, but they don't have any voting right. And by virtue of which they lose out the entire outstanding dues. So, yes. As
invariably, medium scale and small scale industries, you will have one single bank. So it is invariably the COC of 100% of a bank. Yes. Same company, you will have hundreds of operational creditors, either persons who have rendered service, either persons who have sold goods. So that is the fact situation.
Thank you, sir. So now coming back to going to the commercial law's perspective, the Commercial Courts Act, and this question is addressed to Honorable Justice Sendil Kumar Ramamurthy. The Commercial Courts Act seems to draw inspiration from Part 58 of the Civil Procedure Rules in UK. But the only difference I find is that insofar as the rules in UK are concerned, it is more, it's not exhaustive, it's more inclusive, whereas here it appears to be exhaustive. Would you think that the Commercial Courts Act here defining what commercial disputes would be to be exhaustive, would it be in our interest? Or it could have proceeded in the manner perceived in the UK to be more inclusive?
Again, I have to begin with a caveat because in my role as judge, I receive a statute as enacted and interpreted. But said that, as you point out, Part 58 of the CPR, which inspired the Commercial Courts Act, provides for an inclusive definition of commercial disputes encompassing any dispute arising out of trade and commerce. And then inclusively the enumeration is done. By contrast, when you look at Section 21C of the Commercial Courts Act, it begins with means. Fortunately, it proceeds to say arising out of, which expands the scope to an extent. But nonetheless, you'll have to fit it in at least broadly within one of the enumerated entries. And if you look at the enumerated entries, you will find that the endeavor of Parliament for some reason has been to very sort of precisely stipulate the categories of commercial dispute. For example, you will find commercial disputes arising out of, let's say, joint venture agreements or arising out of shareholder agreements. There is no reference to share purchase agreement. There is a reference to share subscription agreement, but only in the context of contracts relating to services. So this type of enumeration actually causes a lot of issues relating to jurisdiction. In fact, even if you look at the first entry, which deals with ordinary transactions of merchants, traders, and so on, an illustration is provided, such as those arising out of mercantile documents. You will come across a number of cases where an objection is raised saying that this doesn't arise out of a mercantile document, although it is intended to be illustrative. So overall, I would say, the drafting of Section 21C could certainly have been improved on, and especially after the amendment whereby your, the floor is now set at rupees 3 lakhs. I think the idea should be that it should encompass all disputes arising out of trade and commerce. But that's for Parliament to revisit at an appropriate time.
Thank you, sir. Coming back to the Commercial Act, at least the SICC in Singapore, which is both international and commercial in nature, what I've noticed is that there's a timeline for filing a defense statement of 28 days from the date of service of summons or from the date of the application being served on them. Now, my question to either Alex or you, Mr. Jalan, is that is this 28 days sacrosanct in the sense that does the defendant forfeit its right from filing a written statement or a defense statement if not filed within that timeline?
The short answer is it's not cast in stone. The rules, the SICC rules, just like any other rules of court, they are meant to be followed. It's a rule of procedure, but the court retains the discretion to extend time. So having said that, in practice, usually time extensions are granted, but if there is no good reason and if it's, there is some inordinate delay, typically happens is the court will impose an unless order or a preemptory order which says that you have to file it by a certain time, failing which then either the defense is struck out or you are precluded from taking any further action. So that's the short answer. It's not cast in stone, right?
Thank you, Mr. Jainal. The reason why I asked you this is under the Commercial Courts Act, here we have a timeline of 30 plus 90 days. And if one does not file it within within 120 days, what happens is that the defendant's right gets foreclosed from filing a written statement. Now, in this context, my last question is to Honorable Justice R. Suresh Kumar, is that, sir, the 30 plus 90 days giving an outer limit of 120 days, would your Lordship consider that to A, further the object of the Commercial Courts Act, B, would it be in the interest of parties in the sense, yes, it would deprive one party, but would it benefit the other, and therefore the overall scheme of things, it would be advantageous insofar as the Act is concerned? That's the question, my Lord.
Well, as I said in my initial speech itself, this Commercial Courts Act, why this Act has been brought in is for the economical progression of the country. That I have narrated that in my initial speech. If you look at the scheme of the Act, why they fixed initially 30 days for statement and subsequently that maximum of 90 days within which the delay can be controlled, beyond which statutorily the court does not have any power to extend it. Many other legislation also having the similar provisions, you know well. This is not the first time the Commercial Courts Act is having such a provision. Many other legislation is having. This become inevitable, otherwise the very object of the Act cannot be achieved. The reason being, if you look at the two important provisions in Commercial Courts Act, one is section 12 capital A. 12 capital A provide for pre-institutional mediation and settlement. If parties are willing, they can go for without any interim relief. If you come to the commercial court, you have to necessarily exhaust the section 12A. Without exhausting section 12 capital A, that you cannot come to the commercial court. To that extent, the 12A has been made. And once, if you go under 12A, having a negotiation, and if you reach the settlement, and the settlement has been reduced in writing, it will have a meaning of like an arbitration award of section 30 of the Arbitration Act. So that much of importance have been given under section 12A. In 12A, during the process, initially 3 months time has been given to complete the negotiation. Thereafter, at the most, either party can ask for extension, that is the maximum of 2 months. 3 plus 2 months only for under 12A. If 12A failure, that you people will come here. Where also, unless this 30 plus 90 is not fixed, then you have to go to section 14. Section 14 makes it that all courts which are dealing with the commercial cases must take an endeavor to complete the case and dispose it up within 6 months. The 6 months period, if you fixed as an outer limit, of course it is not so mandatory because the language used in section 14, but if it is a directive, assuming that it is a directive, that even the directive was given to the courts who deals with commercial cases that you should complete within 6 months, this become inevitable to have this timeline of 30 days, 90 days, under 12A, 3 months, 2 months. These are all in line with the very object of the Commercial Courts Act. Therefore, it will enhance the very functioning of the commercial courts. And the litigants who come for the solution, by commercial litigants who come for the solution, definitely they will be benefited. Yes.
Thank you, my Lord. We come to the end of the first session, and I must thank the Chair, Honorable Mr. Justice Suresh Kumar. I must also thank all the speakers here, Honorable Justice Senthil Kumar Ramamurthy, Mr. Om Prakash, Mr. Jainil, and Alex. Thank you all, and we'll proceed to the second session now. Thank you.
Thank you. Thank you, sir.
I request all the attendees to please remain seated as we are about to begin the second session shortly. I now request the panel members of the second session to please come onto the dais and occupy the respective chairs. Sirs, please. For this session, we have Honorable Mr. Justice M. Sundar, Senior Judge of the Madras High Court, as the chair. Honorable Mr. Justice D. Bharata Chakravarti, Judge of the Madras High Court. Mr. Vijay Narayan, Senior Advocate and former Advocate General, State of Tamil Nadu. Mr. Avinash Pandian, Deputy Head, International Arbitration Co-Head. Mr. Avinash Pradhan, I stand corrected, Deputy Head, Raja and Tan Asia. Mr. Divyesh Menon, Counsel, Raja and Tan Asia, as the speakers. And we have Mr. Naveen Kumar Murthy, Advocate and founder of NKM Law Chambers, as moderator. We'll take the next couple of minutes to honor the panelists on the stage. I now request Senior Advocate Mr. V. Om Prakash to kindly present a memento to Honorable Mr. Justice M. Sundar, Senior Judge of the Madras High Court. I request Mr. Gautaman, Senior Advocate, to present a memento to Honorable Mr. Justice D. Bharata Chakravarti. Sir, please. I request Senior Advocate Mr. Navanitha Krishnan, former Advocate General of the State, to present a memento to Senior Advocate Mr. Vijay Narayan. Sir, please. Sir, I would once again trouble Senior Advocate Mr. V. Om Prakash to please present a memento to Mr. Avinash Pradhan, Deputy Head from Raja and Time. I call upon Mr. Ganesh Chandru, Advocate, to come onto the stage and present a memento to Mr. Divyesh Menon, Counsel from Raja and Time. Sir, please. I call Mr. Gautaman once again, Senior Advocate, to present a small memento to the moderator of the session, Mr. Naveen Kumar Murthy. Sir, please. I now leave the floor open to Mr. Naveen Kumar Murthy, moderator, to commence the session.
Before I begin, I must file an application for condoning the delay as we are running about 25 minutes late with the permission of the chair. And in a lighter vein, with the permission of the chair, may I say that we are an alternative panel to the litigious panel that we had about an hour back. Good evening. Good evening to Honorable Justice M. Sundar, Senior Judge of the Madras High Court. Good evening to Justice Bharata Chakravarti, Judge, High Court of Madras. Mr. Vijay Narayan, Senior Advocate and former Advocate General. And Mr. Avinash and Divyesh from Rajan Tan. As the subject that we're going to discuss in the second session is arbitration and mediation, which effectively are the vital forms of alternative dispute resolution. The Indian framework, as well as the Singaporean and the international framework over the last couple of years, has had drastic changes which we intend to discuss today. The Indian framework has had a Mediation Act passed in 2023, about an year and a half back, where mediation as a proper form of ADR has been recognized. The Arbitration Act of India, which has been amended several occasions, is in for another amendment by virtue of the 2024 amendment bill that is proposed. And the UK Act, which was as similar as the Indian Act in terms of the year in which it was enacted, is gone under the scanner, and we have a new UK Arbitration Act passed this year, hardly a few weeks back. So we intend to discuss on all that aspects in this session. Since mediation is considered to be the precursor to arbitration, my first question is to Justice Bharata Chakravarti, that post the passing of the Mediation Act and removing the chapter of conciliation from the Arbitration and Conciliation Act, has the Parliament made mediation a mainstay and given it the much needed attention it deserved as a form of ADR?
All right. The answer would be yes, but then let me explain it. Originally, there are two terms which are used, conciliation and mediation. Except for the difference in terminology, the process is almost the same. Now, in the Indian context, both the terms were used, either both under Section 89 of the Civil Procedure Code and also the Arbitration and Conciliation Act used both the words, both mediation and conciliation. Therefore, the difference was sought to be maintained by finding a difference that a conciliator can be more evaluative, in the sense that he formulates the proposals for settlement and circulates the parties and invites their objections and hears them out. Like, he is more in the sense of an evaluative thing. Whereas mediation is considered to be facilitative. Now, this difference was maintained with reference to the Indian jurisdiction. As a matter of fact, the entire chapter under the Arbitration and Conciliation Act was adopted pursuant to the UNICITRAL rules which was framed in the year 1980. First, the UNICITRAL rules for conciliation was framed in the year 1980 for the domestic jurisdictions to adopt the same. In that rule, the term used was conciliation. Again, when the UNICITRAL framed the international conciliation law, model law in the year 2002, the term conciliation is only used. But if you see section 2 of that model act, in whatever term it is expressed, whether it is called mediation or conciliation, so the difference got this thing in that legislation itself. Now the Mediation Act, in its definition under section 3, has defines mediation, which includes the same expression, whatever expression, including conciliation. Therefore, it subsumes that terminology also. Therefore, now the Mediation Act has made it clear the term, whether it is called as conciliation or mediation, it is one and the same, and it proposes to remove the words conciliation from wherever it is found in the Arbitration Act, and also under section 89 also the term conciliation is now removed, and only the term mediation is now used. Therefore, now that clarity with reference to the terminology has evolved. As a matter of fact, now the UN Convention, now we call it as the Singapore Convention, has now switched on to the term mediation rather than to the term conciliation. So that now effectively this confusion arose only because of the terminologies, and it is not with reference to the process. And therefore, yes, now the entire chapter has been removed, and only section 61 and 62 is now sought to be put in place in respect of the chapter, which only says that it will only mean mediation and everything will be as per the Mediation Act. We all know that even though the Mediation Act has come into force, what have come into force is section 1, section 3, and some of the sections which relate to the formation of the Mediation Council, and not all the other sections have come into force. So as on date, the chapter under the Arbitration Conciliation Act is still in the statute book, but we are, as you say, we can expect any soon. The answer is yes. Therefore, it wants to clarify that difference, with, especially in the Indian jurisdiction where both the terms were used, and then it wants to streamline and make it effective as the first go for any litigant to resolve the disputes. I hope that answers the question. And thank you for having me here. I forgot that formality before.
Thank you, sir. I think pretty much that answers the question. May I put the second question to the chair, as His Lordship has sat both in the Commercial Division and the Commercial Appellate Division. What has been the impact of 12A under the Commercial Courts Act, which also is recognized under the new Mediation Act, as how effective it is? I understand that I might be entering into controversial terrain, but I would just get a perspective out of the chair on that aspect of it. I think chair can speak through the mic. This mic will read. This mic will read.
Thank you. Good evening, all my brother judges, present and former, fellow panelists, and all who have assembled here. At the outset, my apologies for not being here at 4:30. I'm extremely sorry. I was held up in the dais. By the time I could get out from the dais, it was 5. I'm so sorry about that. Now, on this 12A, Mr. Naveen said this is an alternative panel to the litigious panel. He started with that. I'm reminded of what Jeffrey Was said in his recent lecture in the Manchester Law University. He said this alternate dispute resolution is a linguistic problem. I think I'm loud enough.
Mic is for videos.
Fine, good enough. He said alternate dispute resolution, ADR, is a linguistic problem. He said, please don't use ADR. He said it should be integrated dispute resolution. That's, Jeffrey Was heads the jurisdiction in England and Wales. I think he's made a very, very pertinent point. And section 12 capital A, about which there was discussion in the earlier session also is a good case in point. Very interestingly, if you look at 12 capital A, what is made mandatory is mediation, which is normally an organic process which evolves. In mediation, there is no adjudication. It's just giving away some of your terrain. There's no adjudication at all. But that mediation culminates in an arbitration award under 12A5, which is a product of adjudication. So therefore, there is a nice blend of mediation and adjudication and integration of that into the mainstream statute. So that's one point I wanted to make. As regards 12 capital A itself, I think most of you are aware of partial automation, which said it is mandatory because different high courts were taking different views as to whether 12 capital A is mandatory or merely recommendatory. And ultimately, partial automation settled the law by saying it's mandatory. Thereafter, Yamini Manohar said the court will look into whether there is an urgent interim relief or not. All of you are aware of. The point I want to place for the consideration of the panel and this August gathering is, there is an assuming there is a pre-institution mediation, assuming that culminates in a award. Of course, when the Mediation Act, all the provisions, particularly 63 or 66 kicks in, it becomes a settled mediation. But it's not kicked in. It's not kicked in. As of today, it is only an arbitral award. Can that not be challenged under 34? So 34 does not say that an arbitral award and agreed terms cannot be assailed. It doesn't exclude it from its remit. So therefore, if it's assailed under 34, who assails it? Assuming two parties enter into some agreement which is opposed to public policy, who will challenge it? A third party 34 will not lie. A third party 37 will lie. So these are, I think, grey areas which the lawmakers may have to look into. I think I have reasonably responded to the question. I won't say I've answered. I've attempted to respond to the query that was. All the grounds should be available if there is a challenge. But who will challenge it? A third party challenges. All the 8 are available, but it does not exclude an award made on agreed terms. 35 or 34. What has been on agreed terms? But who will challenge it? Both of them may not challenge it. It may be opposed to public policy. Then what do you do? That appears to be one issue. Should I, as chair, should I initiate something on arbitration because it's a India-Singapore dialogue? Do you want? Yes.
I think two things I must say that the Honorable Chair has answered what we wanted. And as they say, post 5 o'clock, the lawyer and judges come out. We saw that coming out here. So I think that's exactly is the reason why there are dialogues. Just to quickly, since as the chair said, it is integrated and it's quickly gone to arbitration, before I venture into the main subject of it, may I ask Avinash just a winding up question on mediation. What is the take on mediation in Singapore in so far as international disputes? Is there a domestic legislation or are you solely dependent upon the Singapore Convention that Justice Chakravarti pointed out? How effective and how efficient has that been?
Thank you, Naveen. Could I first begin by saying good evening to everyone here? It really is a pleasure to be here, to be addressing you all, and to be in such illustrious company as well. So Singapore has taken a slightly different approach to mediation than India, and I think it's best illustrated by this. It is actually now easier to enforce a mediated settlement arrived at overseas through the mediation convention than it is to enforce a domestic settlement arrived through mediation, because of the provisions of the of the Singapore Convention as brought into force in Singapore. So Singapore, rather than having a statute to govern mediation, has taken a softer approach. And what it has done instead is create an environment to nurture mediation. And in a sense, the approach that Singapore has taken harkens to the point that Jeffrey Voss has made about integrated dispute resolution. And part of what Singapore has tried to do is to create an ecosystem to provide options to litigants in different scenarios where they have a suite of available choices when it comes to dispute resolution, ranging from litigation on the one hand to mediation, to various subsets within mediation, and of course to arbitration as well. So the best, I think, representation of this ecosystem is the institutions that facilitate mediation in Singapore. We have two, the International Mediation Center, as well as just the Mediation Center. But the second big step that has been taken recently, my colleagues just now spoke about the changes to the rules of court in Singapore in 2021. A huge part of those changes was to encourage parties to litigation to try other means of dispute resolution before going down a route of litigation. And this is manifest in two ways in particular. One is that for many types of action, it is almost mandatory. I say almost mandatory because there are slight qualifications. But it is almost mandatory for parties to a dispute to try and resolve their dispute without having recourse to the courts before they can go to court. Now, the way in which they do that can be through the form of issuing an offer to settle, but what we have seen over the past few years is the increasing popularity of mediation as a choice for trying to facilitate a settlement. The second innovation, some might say, I don't think it's an innovation to India, but it's an innovation to Singapore, is the strength of the court's role in encouraging parties to mediate while their dispute is pending resolution in courts. So that is something that is given effect to in the new rules, and it is something that the courts take very seriously, and it is something that is proving to be very successful.
Thank you, Avinash. As mandated by the chair, as I am a mandamus, I go straight to arbitration. My next question is to Mr. Vijayanarayan. Sir, you have seen the new arbitration bill that is in the pipeline, the 2024 bill, that brings about sweeping changes to the arbitration landscape. Do you think that the several provisions contained in the bill is a way forward, or do you think there are going to be much complications caused in the event we adopt the course that is suggested in the bill?
First of all, my respectful greetings to all the judges here and all fellow advocates. I think your question is a very pertinent question, because if we look at the history of what has been happening in this country, one of the most significant developments since independence was in 1991, when India decided to integrate itself with the economy of the world, and we embarked on a path of liberalization. In the early days, we invited foreign investment, but it is not enough to just invite foreign investment. We necessarily had to set up the physical infrastructure so that people who wanted to invest in this country could do so knowing that they would have an infrastructure which would satisfy their requirements. Therefore, we needed ports, roads, airports, all those kind of constant electricity at constant voltage. And after the initial round of infrastructure building, the government of India also realized that for foreign investors to come into this country and invest, there would be commercial relationships and commercial litigation. And one had to have a very robust judicial system in place to deal with such litigation. Now, most foreign investors, because of their historical reasons, preferred arbitration to court proceedings. And at around the same time, about 5 or 6 years after our initial liberalization program, the unilateral model law had come, and we also jumped onto the bandwagon. And this happened in 1996, as it happened in many other jurisdictions. Over a period of time, we realized that there were many clogs in the whole process of arbitration, which resulted in one or two amendments coming, mainly in 2015 and 2019. But the government also realized, as one of the speakers in the previous session was remarking, I think it was Justice Suresh Kumar, the ease of doing business. And ease of doing business has many parameters, one of them being a very quick resolution process for disputes. The government has been trying its best to shorten the process of dispute resolution in a number of ways. And if you see all the amendments that have taken place in the Arbitration Act, they have all been focused primarily on quickening the process of dispute resolution, because foreign investors don't want to litigate endlessly in India, and we were acquiring a sort of a reputation for long litigation processes. So I have just gone through the 2024 bill, which is in a stage of consultation, and I find that the government has really taken a lot of thought and effort to try and quicken the process of litigation. There are some key takeaways. I mean, this bill has made some very drastic and far-reaching amendments to the Act. And I'll be very interested in knowing how it finally pans out. But I'll just very quickly give you some of the key features of the 2024 Amendment Bill. Now, firstly, they have imposed certain very strict timelines for Section 8 applications, that is when a person goes to court instead of honoring the arbitration agreement. Those applications have to be decided within 60 days. Then Section 16 applications have to be decided within a period of 30 days. And those should also always have a preliminary issue. Then emergency arbitrations are for Section 9 can now be instituted on the basis of an application made to an arbitral institution. Then Supreme Court and High Courts can designate institutions recognized by the Council. So there is an arbitration council, and those will, earlier they had to grade the institutions, but now they just have to recognize them. And once they are recognized, it is up to each Chief Justice of a High Court or the Chief Justice of the Supreme Court to designate them as arbitral institutions. And I think it's very important that we should move to a regime of institutional arbitration, because high courts are overloaded with work. Section 11 applications can go there, and a lot of problems which we are facing today can be sorted out if it goes into institutions rather than the courts. Then as far as one of the other key takeaways from the proposed amendment is fees under a new Section 11A. It can be either by agreement between the parties, or by the rules of the institution, or prescribed by the Arbitration Council. Interest has also undergone a change, Section 31. It is now 3% higher than the repo rate, which is the rate at which the Reserve Bank of India lends to commercial banks. Now, what is very interesting is that under Section 34, one is now given an option to either go to the court under Section 34 or to an appellate tribunal. Now, this is a fascinating proposal, because the problem with Section 34 was that though Section 29A prescribes a time limit of 1 year with an extension of 6 months to the arbitrators to decide the dispute, further extensions being granted only by the court, which means that 29A imposed a very strict timeline on arbitrations. Eventually, when the matter went to a Section 34 petition, it may get stuck in the court for 4 to 5 years, sometimes conceivably longer than that. I am doing a case next week where the 34 petition was instituted in 2014, and 11 years later it has not even gone through the stage of Section 34. But if an appellate tribunal is constituted for that dispute, a 34 in relation to that arbitration award, one can only imagine that it can be disposed of very expeditiously. Now, the limitation that we have is that in a Section 34 application, there is one judge allotted in a high court to decide all Section 34s. And it is humanly impossible for that judge to tackle the arrears which have been pending for maybe 5 to 10 years, as well as the fresh cases that are coming on a daily basis. Whereas under this new provision, one appellate tribunal could be constituted for each section, for each award. Thereby, conceivably, even 30 to 40 tribunals could be constituted, so that the Section 34 gets disposed of possibly within 6 months. And against that, there is a right of appeal under 37, which goes to a division bench of the High Court. Therefore, that oversight by the High Court will still remain as it is. Now, this is a fascinating provision which I think would, to a great extent, make the whole process much quicker. Then the other provision is that Section 34(2)(a), there is a small a by which the award can be set aside as a whole, and there is now a new Section 34(2)(a) by which it can be set aside in part. But still, the question of modification has not been really addressed in this amendment. Of course, that issue is pending before the Constitution Bench, and they have reserved orders recently. But there is an indication that modification still cannot be done, because even if you set aside a part of the award, there is a further provision in the Act that the court which sets aside that part, the court or the appellate tribunal which sets aside that part, can remit that part to be decided again by the same tribunal within a specified time limit, which seems to indicate that the court under 34 or the tribunal under 34 still cannot modify the award, and therefore we have to look forward to the judgment of the larger bench to see what they do. The other thing is that under 43C, which are the new provisions which came in 2019 and which have not yet been notified, and probably it will now be notified once the Arbitration Council is formed and they make their rules and the various other functions that they have to perform under this statute. But what is surprising, to use a very mild word, is that all the members, 6 members of the Arbitration Council, are all nominated by the Government of India. It looks like they did not reserve any sort of power or interference, or rather suggestion or input from the judiciary. And I think there, I would not like to comment on it, but I certainly don't agree that the judiciary should have been entirely excluded from the process of finding a place in the Arbitration Council, because eventually it is only the higher judiciary which has oversight over this whole process of arbitration, whether it is a High Court under 34, 37 or the Supreme Court under 136. Certainly there should have been some involvement of nominees of the Honorable Chief Justice of India. Now, these are the key takeaways from the new arbitration bill, and I hope there are very many good points in terms of trying to shorten the whole process, because that has been the constant endeavor of the Government of India to have minimum judicial intervention and the quickest possible solution to disputes. But I hope that this will, it's in the public consultation stage, but I hope that it will be passed into law as early as possible.
Thank you for a very deep insight, sir. Just to give a comparative transnational perspective, I ask Divyesh, as Mr. Vijayanaran pointed out, the new law has a way in which there is an appellate tribunal against an award passed by an arbitral tribunal. And also, insofar as modification is concerned, the constitutional bench of our Supreme Court is now seized with the matter on the legal question as to whether an arbitral award could in fact be modified by a court to make it effective. What is the takeaway in Singapore? How does the Singapore law view in it so far as appellate arbitration is concerned and modification by courts are concerned?
Thank you, Naveen. And I must join everyone who has come before me in thanking the Honourable Justices, senior advocates, and members in attendance for the opportunity to be here. So the question of what happens after setting aside is, in Singapore, actually very, very clear. And it's been for quite a long time. When a Singapore court is faced with an award which is ultimately impeached or impugned because it is a breach of one of the principles of the New York Convention, it has a few choices. Either it declines to set aside, okay, if nothing is wrong, or if sets aside in part, and partial setting aside is expressly recognized within the statutes and is a power of the courts, or it sets aside in full. And if it sets aside either in part or in full, it can, in part, it can remit that part of the award to the tribunal, which otherwise would be functus officio, to consider the point. Now, that particular power of remission is not something that has actually received a lot of judicial attention yet. In part because the nature of the breaches the courts have found in quite a number of cases are so intertangled with the rest of the award that remitting a simple one discrete part back to the tribunal wouldn't be appropriate. But it potentially leaves an interesting question. In what case is it appropriate or suitable to remit an award back to the same tribunal? Because if you think about it, the tribunal essentially got it wrong the first time. And there is one argument that if you remit back the award to the same tribunal, that tribunal is already colored with a particular result. And it wants to protect that and achieve that same result. It simply reconsiders the point but draws the lines in a way which achieves that result. But that's the question of remission. And I will also say that in some cases, it leaves potentially a lacuna, and that's a lacuna in this case, which the Indian legislation is seeking to address. Can a court modify an award, essentially sit in place of the tribunal that has got it wrong and correct the course? That's simply not a power that is available in Singapore. I must qualify that we have two regimes. There's the International Arbitration Act, which applies, as you've heard in earlier panels as well, to international and commercial cases. But there's also an Arbitration Act, which applies to purely domestic cases. In the purely domestic cases, there is a mechanism, which you can opt out of if you want to appeal on a question of law. But that's a very limited point. So essentially you're saying on a question of law, the tribunal got it wrong and you appeal up to the court. And there is still some basic thresholds that you have to cross to get there. But that's an option that's available. And the court, of course, if it decides differently from the tribunal, can substitute its decision. But that's not a power that is available to the courts in the International Arbitration Act. So essentially that question is foreign to us in that sense. It's the powers or the consequences of setting aside. There is some sympathy because if you're a party that has gone through the entire arbitration, got a tribunal that's given you an award wrongly, then what do? You start it all over again potentially, and that's essentially the game that some people actually game out to try and achieve.
Thank you, Divyesh, for that perspective. Since you pointed about international commercial arbitration, now I go straight to the chair. International commercial arbitration regime has, of course, gone through changes by the 2015 amendment and the 19 amendment. 2015 more so by amending section 48, where public policy and explanation has been added to. My question to the chair is, has that made things worse or has that made things better? And more recently, the Delhi High Court Division Bench in a huge arbitral dispute in the KG Basin's case has set aside an award, saying that it would not have the trappings of an international commercial arbitral award since one of the parties is predominantly Indian. So what is your Lordship's take on that?
I'll take this opportunity to clarify one position which may be of use to the younger members of the bar. When we say international commercial arbitration, that is not based on the seat. That is based on whether one of the parties is Indian or not. If one of the parties is not Indian, or if both are not Indian, be it an entity or an individual, that becomes an international commercial arbitration within the meaning of 2(1)(f). So it's governed still only by Part 1. It is only a domestic award. Whereas Part 2, foreign award, is when the seat of arbitration is not India. So I just wanted to clarify, because this expression international commercial arbitration is being loosely used. International commercial arbitration can result in a domestic award. That's the point I wanted to highlight. On 48 itself, that is New York Treaty. That presumes that an award is enforceable, and the person against whom it is sought to be enforced should be able to demonstrate. And that is nothing but a mirror of 34, the grounds available, 8 pigeonholes available for setting aside, except patent illegality, 2 capital A. Whereas if you go to the Geneva Convention, Chapter 2 of Part 2, that does not presume that it is enforceable in India. It is for the party seeking enforcement to demonstrate. There's a difference in the language. So that's one thing I wanted to. And this KG Bazin, subject to correction, is a domestic award. It's not a... it's a domestic award. So that was on a 37... so that's one aspect of the matter. But I thought I'll just quickly, considering the exigency of time, I thought I'll quickly highlight, now that it is a Indo-Singapore dialogue, I thought I'll just quickly raise one issue where there appears to be a difference in approach when it comes to Curial law, governing law for the arbitration, and proper law for the contract. The essential distinction is only with regard to governing law for the arbitration. See, the Singapore position, as I understand, is BCY versus BCZ, 2016 SG HC 249, subject to correction. Share purchase agreement, foreign bank, all that. Normally, before we go into this, the point is, there are 3 streams of law whenever you talk of arbitration, particularly when with regard to foreign awards. Any country for that matter. I'm not talking about India, be it India, Singapore, England or France. Stream 1 is proper law for the contract. That is the law that is made applicable for interpreting the contract. Stream 2 is Curial law. Curial law is the procedure for arbitration. That's also fairly simple because it follows the seat. Assuming 2 Indian entities enter into an agreement and the seat is ICC London, the Curial law becomes English law. There's no difficulty about it because seat is ICC. Now the conundrum is with regard to governing law for the arbitration agreement. In my limited experience, subject to correction by the others who might be, who might have greater exposure to agreements involving more than one country, parties in more than one country, one nationality. The governing law for the arbitration agreement is never spelt out. It has to be inferred. Such an issue arose in Singapore High Court, SGHC 249, BCY, BCZ. I'm not boring you with the facts. It's a share purchase agreement. There ultimately what was concluded in Singapore is, when the governing law for the arbitration agreement is not spelt out, it would effectively be the proper law for the contract. Depassage doesn't apply. Depassage is a principle where different sets of laws are applied to different parts of the same contract. Depassage is
an exception. The parties are expected to be governed by the same set of laws. This is the Singapore position. But come to India, Balco, 2012 9 SEC 552, we are closer to the English position. We are saying the governing law for the arbitration agreement would be the Curial law. English law was settled in ENCA very recently, where there was a nuclear station which was devastated in a fire, and the insurance company made a claim against one of the subcontractors. A suit was filed in Russia, anti-suit in England. There in ENCA, the English court, in fact the Supreme Court of England in ENCA, by a 3-2 majority, decided that it would be the Curial law. Now, as between Singapore and India itself, there is a difference in approach. Number one, if we could discuss more on this, if it can be homogeneous, and if the approach of the international community is in sync with one another, it might give greater certainty to the litigation part of arbitration, number one. Number two, to decide this, do you start from Curial law or proper law for the contract? You apply it, it will lead to the reverse situation, depending on where you start from. So probably I'm just throwing open that for discussion.
Thank you, sir, because it's a wonderful point of discussion. It's a very interesting area of law. Maybe I can start by making this observation, that actually with ENCA and the English position, actually the case is very peculiar, and its history traces back to a Court of Appeal decision called Sul America. And what the English courts effectively got to was, including in ENCA, was the point that generally you have to apply a choice of law analysis, express choice, or can you infer an implied choice? And the struggle for the courts was always that when you looked at the way a contract was drafted, it seemed natural to deduce that you could imply a choice from the choice of law for the substantive obligations. Because when you look at what the law of the arbitration agreement is meant to govern, it's meant to govern questions such as the formalities with respect to the entry into the contract, or whether there's been sufficient requirements for the constitution of the arbitration agreement itself, amongst other matters. So what Sul America and ENCA later followed was to say that, well, proper law, but if we find that the proper law creates some sort of problem with respect to the enforceability of the arbitration agreement, then we will apply a presumption of validity. And that presumption of validity would then mean we move away from the proper law to the Curial law. Now, this decision in the UK and England was the subject of a lot of commentary among international arbitration circles. Because frankly, if you think about it, one of the huge reasons why parties into an international transaction choose arbitration is because they want to remove themselves from the specifics of any national court, and what they want to try and do is come to a more international forum. That's not the type of consideration that will necessarily apply to a choice with respect to the substantive law obligations under the contract. So it's very particularly interesting because if one looks at the 2025 English Arbitration Act, the act that has just been passed that Naveen referred to, the English legislature has changed the position in ENCA. And what is now put in place is a specific provision to say, one, of course, if the parties agree expressly to the law of the arbitration agreement, that will be given effect to. Two, if not, there is a presumption. And the presumption is that it is the Curial law that applies. And the third point is that there's going to be no presumption on the basis of the party's choice of governing law. So it's amazing because what has happened is the legislature has gone with the international arbitration community, put to bed all that authority, Sul America, ENCA, that's gone, and it is now very clear that except in very extraordinary circumstances, it is always going to be the Curial law that is the law of the arbitration agreement. Now, I just say that I think that is very sensible for the primary reason that ultimately when parties choose international arbitration and they choose a seat, what they want is a seat that really protects the integrity of the arbitration agreement. And usually it would follow that when you choose that seat, you would also have in mind that the entirety of your agreement to arbitrate is governed by the law of that seat. Singapore is one step behind for the reasons that you have mentioned, sir, because we are still in the ENCA territory, and the ENCA territory remains, well, maybe proper law, but if there's a presumption we will apply the presumption of validity, so if the proper law creates a problem for the arbitration agreement, then we will go to the Curial law.
Thank you, Avinash, for that insightful and a comparative answer. Thank you, Avinash, for that insightful and comparative answer. And since you had come to the UK Act, I think the UK Act is in both answered a conundrum that Honorable Justice Sundar has pointed out with regard to ENCA and the other judgments that was stuttering it back. As in fact, in one lecture, I just heard the intention of the UK Act is to make UK as competitive as Singapore as a hub in arbitration, because the turnover that they make as arbitration community is 2.3 billion pounds. So just one point, just brushing off from the UK Act. The UK Act discusses something about summary awards and summary arbitrations, something that the Indian Parliament has been conspicuous and conscious of not including. So what is your take on summary awards? Because what was discussed in the previous panel, the Commercial Courts Act, it does have summary proceedings. But in arbitration, do you think having a summary award where you say that a claimant is most likely to succeed, a respondent is most likely not to succeed, as a ground to pass an award, how effective do you think it would be there?
Thank you. I would first start by observing that if one looks at the rules of the International Chamber of Commerce, or if you look at the SIAC rules, for example, both those rules contemplate the possibility of issuing summary awards. Now, the SIAC does it expressly. It actually provides for a provision for the dismissal of a claim or a dismissal of a defense if the other side's case is manifestly unmeritorious. That is actually borrowed from the ICSID Convention, that language. So it actually has a long history. The ICC doesn't expressly regulate it in its rules, but through the guidelines to the ICC rules, you can see that the case management powers that an arbitrator has include the power to summarily dismiss a case. I would suggest that actually you don't need any specific statutory intervention to recognize a power for summary dismissal if the basis for summary determination is that even on the facts as pleaded by either party, as a matter of law, the claim can be dismissed and correctly dismissed, or whichever way it is, whether it's the claim or the defense. And the reason I say that is that if usually when one looks at the question of challenge, one has to look at it from the perspective of whether there's been a breach of natural justice. Now, if the facts pleaded are assumed to be true in the analysis of whether a summary determination is appropriate, and a party is given a full chance to argue its case on whether the summary determination is appropriate before the tribunal comes to its decision, I would suggest that in those circumstances there is no breach of natural justice. And if there is no breach of natural justice, it would follow that there is no reason to set aside the award per se. So then you are left with the other grounds for setting aside. Want of jurisdiction, I don't think that would apply. Public policy, of course, is the other question. But I would again suggest that if under the rules of natural justice, if the party's opportunity to present a case has been respected, then it does not seem to me that there is any compelling public policy reason to not recognize the validity of the award. So I would put that out there.
Thank you, Avinash. I'll just push back and ask Justice Sundar a question on the aspect that Mr. Vijayanaran had pointed out about ad hoc and institutional arbitrations, and it was Mr. Vijayanaran's suggestion that institutional arbitration is a way forward. Does your Lordship think that that is going to be answering or curing a lot of difficulties that we face now if effective institutional arbitration regime is what we're heading towards?
Sorry, the last part, can you say that
Is
again?
the institutional arbitration regime that we're heading towards, is that going to be an answer to the lot of issues that we face now in terms of judicial delay and the other aspects that Mr. Vijayanaran had pointed out?
It's not capable of a binary answer. It depends on how it works. But on a broad first principle, I would say institutional arbitration is any day better qua ad hoc arbitration. That would, one, there is some codification. Two, there is some interface between the arbitral tribunal and the parties. Three, the arbitral tribunal is not burdened with administrative details. So therefore, I would always prefer, now part 1, capital A of Arbitration Conciliation Act in India has also kicked in. That has also been notified. And one of the former honorable judges of the Supreme Court has been put in charge of the whole exercise. So it is taking shape in India too. So I think that before that, I just wanted to go back to that Curial law, governing law for the arbitration, the adjectival law. It's so fascinating. Now, the latest one is Anupam Mittal. So we may have a dialogue on that because Anupam Mittal takes a slightly different. Your BCZ followed the Sulamerica, but here Anupam Mittal seems to take a slightly. That is 2023 SGCA 1 is the citation subject to correction. So considering the exigency of time, not going more into it.
May I request Avinash to respond in a minute quickly, if you can, so that we get that could be the last one to knock it off.
It is a fascinating decision, Anupam Mittal. I would say that it is probably incorrect. I would say that it's incorrect for two. Well, I first say that it's very interesting because in Anupam Mittal, at the time the judgment was released, Enker had just come out, but Anupam Mittal doesn't discuss Enker at all. And just for the benefit of the audience, Anupam Mittal was a case about it was a shareholders or share subscription agreement dispute and shareholders dispute. There were parallel proceedings in the NCLT here. And what had happened was one of the parties had got an injunction from the Singapore courts to stop the other party from proceeding in the NCLT on the basis that the dispute before the NCLT should be referred to arbitration. And of course, the response was that the NCLT is a tribunal of exclusive jurisdiction with respect to minority oppression actions in India, and therefore no arbitral tribunal can make a decision on that type of action. And in that context, the Court of Appeal of Singapore had to decide whether the Court of Appeal had to decide whether the question of minority oppression could be arbitrated if the law of the arbitration agreement was Indian law. And what the Court of Appeal basically did was it decided that the law of the arbitration agreement was not Indian law. It was Singapore law. And the reason it... Correct, yes. It applied a closest connection test. And the way it reasoned this closest connection test is quite convoluted. And I cannot explain it in 1 minute because it's convoluted. But I would say that ultimately the court was very moved by the idea that in reading the contract and the arbitration provisions, it thought that the parties had really wanted these disputes to be arbitrable, to be decided in arbitration. And so the court applied a presumption of validity and decided, therefore, the implied choice of the parties must have been to choose Singapore law as the law of the arbitration agreement, because under Singapore law, minority oppression disputes are arbitrable.
Thank you. With the permission of the chair, may we, I think...
Last word. In Enka has now been nullified by the 2025 Act.
Yes.
Enka, there is a strong dissenting word.
Yes.
Lord Burrow. Lord Burrow and Sales have written, which I feel is jurisprudentially very strong. That has now become law.
You're absolutely right. You're absolutely right. And I think Actually, ENCA is worth a read because it is a excellent judgment, and if you get the law reports and you read the arguments, they're excellent as well. And it really shows you the depth of the policy considerations that inform the court's reasoning on these types of issues. But absolutely right, sir, that Lord Burroughs' dissent is a worthwhile read, absolutely worthwhile.
Thank you, Avinash. And as they say, the beauty of a speaker or a beauty of a discussion is, by the time the audience gets restless in their seats, it completes. I think that's what has happened here. I think, though we would like to discuss more, I think time and the Honorable Chair have indicated that we... so I think, if with the permission of the Chair, can we take 2 questions? Get the mic.
Yes. Yes.
And what is the procedure contemplated for such a tribunal?
I don't see any particular procedure contemplated in this act. So I suppose that if there is no agreement between the parties, then there will be recourse to Section 11.
Again, you come back to the court.
No, it goes to an institution.
It goes to the institution.
It goes to an
No,
institution.
appellate tribunal, the institution will appoint.
Yes, the institution will.
For every
Once
award.
institutions are designated, then everything moves to the institution.
Gautam, Senior Counsel Mr. Gautam.
Reversal of roles.
I know your Lordship holds Hakim sacrosanct. Now, from what I understand...
No. Article 141.
Fair enough. Your Lordship is
Article
bound by
141 is sacrosanct. Article 141 is sacrosanct.
Fair enough. I'll say that...
Judicial discipline.
Fair enough. I don't want to take your Lordship's personal take on this, but if the proposed amendment permits the court to actually amend the award or set aside a portion of the award, instead of remission, if the court can decide it, if your Lordship feels that the ratio laid down when Hakim will be better, or we are better off having a portion of the award set aside and give a finality to the award.
The Hakim now is reserved. No? Hakim larger bench is reserved.
Fair enough. Let's assume for a moment the larger bench confirms Hakim.
So I would gravitate towards silence. Considering 141, because it's reserved.
No, I'm asking purely in terms of the proposed amendment. Let's forget Hakim for a minute. If supposing the proposed amendment permits your Lordship to set aside a portion.
Upon Hakim.
Yes.
Which the Supreme Court is...
Fair. I'll not trouble your Lordship. My last intention would be to put your Lordship into trouble.
No, just a matter of judicial discipline.
Thank you. One last question.
I think Naveen, even before I spoke, to clarify that, because I saw this Indo-Singapore bar dialogue. I saw Singapore bar nicely dialoguing with Madras bench. Madras bar didn't get opportunity. That's what I want to tell you. You corrected already. Thank you so much.
Thank you so much. With the permission of the Chair, maybe, so that the vote of thanks Mr. Trivengadam can.
Honorable Mr. Justice M. Sundar, Honorable Mr. Justice R. Suresh Kumar, Honorable Justice Sendil Kumar Ramurthy, Honorable Mr. Justice D. Bharata Chakravarti, Honorable Justice N. Satish Kumar, Honorable Justice Krishnan Ramaswamy, Honorable Justice former Judge Chandrasekhar, now Chairperson DRAT, Senior Advocates, and advocate members of the bar, distinguished guests from Raja and Tan Asia, Singapore, friends from the press, media, ladies and gentlemen, good evening. It's an honor and privilege to address you as we conclude Lex Charter 2025, India-Singapore Bar Dialogue. On behalf of the Madras Bar Association, I extend our deepest gratitude to all of you for invaluable presence and engagement. We have contributed immensely to the success of this event. A special note of appreciation to the Honorable Mr. Justice M. Sundar, Honorable Justice R. Suresh Kumar for chairing this esteemed event. We also extend heartfelt thanks to Honorable Justice Sendil Kumar Ramurthy, Honorable Justice Bharata Chakravarti, Senior Advocates Vijay Narayanan, and Mr. Om Prakash for their invaluable contribution. Your expertise and commitment to the legal profession serve as an inspiration to all. A special word of thanks to our distinguished speakers from Raja and Tan Asia, Singapore, Mr. Jainil Bandari, Alexander, Mr. Avinash Pradhan, and Divyesh Manin, who have taken the time to be here. Your insights on commercial and insolvency, maritime, arbitration, and mediation laws have provided us with crucial perspectives. Thanks to moderators Arjun Suresh and Naveen Kumar Murthy, who have not only moderated and also expressed knowledge and skill in this field. Our gratitude extends to the honorable judges and former judges of High Court for gracing this occasion, and to the esteemed members of the bar for active participation. A heartfelt thanks to our friends from the press and media for covering this event and ensuring this important discussion reach a broader audience. A special mention to the organizing team for their dedication and seamless execution of today's event. Thanks to the Madras High Court administration for permitting us to use the venue on a short notice. The collaboration between the Madras Bar Association and Raja Tan Asia has fostered a meaningful exchange of legal knowledge between India and Singapore. As we conclude, I am confident that the insights shared today will resonate in our professional journeys and pave the way for further engagements between our legal communities. Once again, I thank you all for making this event a grand success. I look forward to have many more meaningful dialogues in the future. Thanking you. Thanks everyone for patiently waiting all this time.
I request everyone to please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तब शुभ आशीष मागे गाहे तब जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Enjoyable discussion. I'm sorry we couldn't carry it on. We'll carry it on 2026. 26. We'll have a lot more to discuss. Very, very